Your rights. Under our American system of justice, all persons are presumed to be innocent until proven guilty. The state must prove you guilty beyond a reasonable doubt of the offense with which you are charged. Every criminal defendant has the right to remain silent and refuse to testify without consequences. You have the right to retain an attorney and have them try your case or answer your questions. Since offenses in this court are punishable only by fine and not by incarceration, you do not have the right to appointed counsel. You have the right to a jury trial. You may waive a jury trial and have a trial before the judge, commonly called a bench trial. If you elect to represent yourself, no person other than an attorney can assist you during a trial. At trial, you have many rights, including the right to have notice of the complaint not later than the day before any proceedings in the prosecution, the right to inspect the complaint before trial and have it read to you at the trial, the right to hear all testimony introduced against you, the right to cross-examine witnesses who testify against you, the right to testify on your own behalf, the right not to testify. Your refusal to do so may not be held against you in determining your innocence or guilt. And you may call a witness to testify on your behalf at the trial and have the court issue a subpoena, a court order, to any witnesses to ensure their appearance at the trial. The law provides that you have the following rights. You have the right to retain counsel to advise you. You have the right to remain silent. You have the right to have an attorney present during any interview with peace officers or attorneys representing the state. You have the right to terminate an interview at any time. You have the right to request the appointment of counsel if you cannot afford counsel. Appearance. In addition to your rights, you have some legal responsibilities. The law requires you to make an appearance in your case. Your appearance date is noted on your citation, bond, summons, release papers, or order of the court. You or your attorney may appear in person, in open court, or by mail. You may deliver your plea in person to the court. Juveniles have a separate set of rules for their appearance. Please read the children's pamphlet. Your first appearance is to determine your plea. If you waive a jury trial and plead guilty or nolo contendere, no contest, you may present extenuating circumstances for the judge to consider when determining the proper punishment. If you plead not guilty, the court will schedule a jury trial. You may waive a jury trial and request a bench trial. When you make your appearance by mail, your plea must be postmarked by your scheduled appearance date. If you plead not guilty, the court will notify you of your next appearance date. If you enter a plea of guilty or no contest, you must also waive your right to a jury trial. You may request the amount of fine in writing and mail or deliver it to the court before your appearance date. Fines are due when assessed. If you are unable to pay the fine when assessed, you may request an extension from the judge. Pleas. Unless you are entitled to a compliance dismissal, you must enter one of the following three pleas. Plea of not guilty. Plea of not guilty means that you deny guilt and require the state to prove the charge. A plea of not guilty does not waive any of your rights. A plea of not guilty does not prevent a plea of guilty or no contest at a later time. Plea of guilty. By a plea of guilty, you admit that you committed the criminal offense charged. Plea of nolo contendere, no contest. A plea of nolo contendere means that you do not contest the state's charge against you. The difference between a plea of guilty and nolo contendere is that the no contest plea may not later be used against you in a civil suit for damages. For example, in a civil suit arising from a traffic accident, a guilty plea can be used as evidence of your responsibility or fault. If you plead guilty or nolo contendere, you will be found guilty and should be prepared to pay the fine. A plea of guilty or nolo contendere waives all of the trial rights discussed earlier. If you are unable to pay the entire fine and costs, you should be prepared to document and explain your financial situation. Fines, costs, and fees. The amount of the fine assessed by the court is determined by the facts and circumstances of the case. Mitigating circumstances may result in a lower fine, and aggravating circumstances may result in a higher fine. The maximum fine amount allowed for most traffic violations is $200. For most other violations of state law and city ordinance, is $500. For fire, safety, health, zoning, and sanitation ordinance violations, $2,000. Courts are required by the laws of the state of Texas to collect court costs and fees. Because costs vary for different offenses, Check with the court for the amount of costs that will be assessed for the violation with which you are charged. If a warrant was served or processed, a $50 warrant fee is assessed. If you do not pay the whole fine and costs within 30 days of the court's judgment, you must pay an additional $25 time payment fee. Court costs are only assessed if you are found guilty at trial, if you plead guilty or nolo contendere, or if you are granted deferred disposition or a driving safety course. If you are found not guilty or the case is dismissed, court costs are not assessed. Judge's ability to dismiss. The municipal judge is responsible for conducting a fair, impartial, and public trial. The case against you is brought by the state of Texas through the prosecutor, not the court. Therefore, the judge may not dismiss a case without the prosecutor having the right to try the case. There are several exceptions to this rule, including deferred disposition, driving safety courses, and in compliance dismissals. Driving safety course. If you are charged with a traffic offense, you may be eligible to ask the judge to take a driving safety course to dismiss the charge. The request must be made on or before the appearance date on the citation. It must be made in person, by counsel, or by certified mail. If you are under age 17, you must appear in open court with a parent or guardian to make the request. If you are operating a motorcycle, you may be required to take a motorcycle operator's training course. If you are charged with allowing a child to ride unsecured in a safety belt or a child passenger safety seat system, you may take a special driving safety course that has 4 hours training on child passenger safety seat systems. At the time of the request, you must do the following: plead guilty or no contest, pay court costs, pay a $10 administrative fee if required, present proof of financial responsibility, insurance, and present a valid Texas driver's license or permit. Active military and spouses or dependent children of active military may present a valid driver's license from any state. To be eligible, you cannot have taken a driving safety course or motorcycle operator's course for a traffic offense within the last 12 months from the date of the current offense. Cannot currently be taking the course for another traffic violation. Cannot be the holder of a commercial driver's license, CDL, or have held a CDL at the time of the offense, and have not committed one of the following offenses: failure to give information at accident scene, leaving the scene of an accident, passing a school bus, a serious traffic violation which applies to commercial motor vehicle operators, an offense in a construction or maintenance work zone when workers are present, speeding 25 miles per hour or more over the limit, or speeding 95 miles per hour or more. The case will be deferred for 90 days. During that time, you must complete a driving safety course approved by the Texas Education Agency or a motorcycle operator's course approved by the Department of Public Safety, and present the completion certificate to the court. Present a certified copy of your driving record from the Department of Public Safety that shows that you have not had a driving safety course within the preceding 12 months from the date of the current offense. And swear to an affidavit that you were not taking a driving safety course at the time of the request for the current offense, and that you have not taken one that is not shown on your driving record. If you do not present the required documents in time, the court will notify you to return to court and explain why you failed. The judge may, but is not required to, allow you to file the proper papers for an extension at that time. Your failure to be present at that hearing will result in a conviction, a fine being assessed, and a capias pro fine for your arrest being issued. Deferred disposition. The judge may, in the judge's sole discretion, defer disposition on most cases. The holder of a commercial driver's license is not eligible for deferred disposition on moving traffic violations. Costs must generally be paid when the court grants deferred. If you complete the required terms, the case is dismissed, and the court may impose a special expense fee not to exceed the maximum fine amount authorized by state law. The deferred period cannot exceed 180 days. The trial. A trial in the municipal court is a fair, impartial, and public trial as in any other court. Under Texas law, you may be brought to trial only after a sworn complaint is filed against you. A complaint is a document that alleges the act you are supposed to have committed and that the act is unlawful. You may be tried only for what is alleged in the complaint. You have the following rights in court: the right to have notice of the complaint not later than the day before any proceedings, the right to inspect the complaint before trial and have it read to you at the trial, the right to have your case tried before a jury if you so desire, the right to hear all testimony introduced against you, the right to cross-examine witnesses who testify against you, the right to testify in your own behalf, the right not to testify if you so desire. If you choose not to testify, your refusal to do so may not be held against you in determining your innocence or guilt. And you may call witnesses to testify in your behalf at the trial and have the court issue a subpoena, a court order, to any witnesses to ensure their appearance at the trial. The request for a subpoena may be oral or in writing. The right to hire an attorney. If you choose to have the case tried before a jury, you have the right to question jurors about their qualifications to hear your case. If you think that a juror will not be fair, impartial, or unbiased, you may ask the judge to excuse the juror. The judge will decide whether or not to grant your request. In each jury trial, you are also permitted to strike 3 members of the jury's panel for any reason you choose, except an illegal reason, such as a strike based solely upon a person's race or gender. Juvenile court procedures. You and a parent or guardian must appear in person in open court. You are not allowed to appear by mail or by delivery of a plea or fine to the clerk's office. You have an absolute right to be accompanied by your retained attorney. Your parent or guardian, however, must still appear with you, even if your attorney accompanies you to court. Dress code. Proper attire is required for everyone entering the courtroom. Clothing must be clean and properly worn. The following are specific items that do not meet the minimum requirements for proper attire: no shorts of any type, no tank tops, no skirts that do not extend to at least the middle of the thigh while sitting, no exposed underwear, no bare feet or flip-flops, no offensive, violent, obscene, or suggestive slogans or caricatures shall be displayed on clothing, no chewing gum or bubble gum. Anyone not properly dressed upon arriving in the courtroom may be sent away until properly dressed, or may be found in contempt of court and subject to a fine or incarceration, or both. Cell phones. All cell phones and other electronic devices must be turned off or placed on silent mode. Cell phones or other electronic devices that interrupt or disrupt court proceedings may be subject to possession, and you may be found in contempt of court and subject to a fine, incarceration, or both.